So it's time for the FDCPA question of the day. So you're getting calls from a debt collector, but you're not getting anything in writing in the mail. What's the deal? Many times this could be a scam of some sort if they're not sending a written notice. It's pretty unusual for a legitimate debt collector to not send something in writing, primarily because it's required by the FDCPA. Now, this doesn't mean it's not a scam. It could be real. But what happens if a debt collector keeps calling you but never sends you any written explanation of the debt? And it's a little bit complicated, so let's break it down and what the requirements are. First of all, the initial contact. The FDCPA says they must provide you, they being the debt collector, must provide you with validation information within 5 days of the first communication. The first communication is via the letter. Usually it's included in that first letter. But it could be a phone call. Many times it's a phone call. So within 5 days of that phone call, they're supposed to send you an initial communication letter. And it's supposed to include certain things like who the debt collector is, probably them, maybe not, I guess. The name of the original creditor, if there's a junk debt buyer involved, the amount they believe you owe, and your rights to dispute that debt. Usually what they'll do is they'll copy that straight out of 15 USC 1692G, which basically says you've got 30 days to dispute it and how to dispute it. But what happens if there's no written letter? Well, does that mean they didn't send it? It's kind of debatable. I can tell you if you sue them for not sending a letter, magically one is going to show up. It probably should come as no surprise to anyone, but debt collectors don't have a problem lying. They will produce a letter that was never sent. It's very easy to do, and they'll testify that that was a letter they sent, and they 100% recall sending that letter, even though it was never sent. Not hard to do, so I would not recommend suing them, generally speaking, for not sending a letter, because the letter will magically appear. The exception will be if it's got like a certified mail, they got to prove they sent it. That's different, but if it's just a regular letter, then I wouldn't be very cautious there. They also might have sent the letter to the wrong address, either accidentally or intentionally. This is not uncommon. They allegedly do some skip tracing. Sometimes they get good information, bad information, and they'll send the letter wherever. Say, hey, we sent the letter. We knew. They probably knew it wasn't the right address, but they sent it to start the clock. Many times they'll send it to family members on purpose to shame you into paying them to get them to stop sending letters to their family members. And of course they'll say, oh, we didn't know. We thought it was your address. They knew. Their skip traces are pretty accurate sometimes, and it will tell you lots of good information, more information than you may know about yourself. But in any case, if you don't get a letter, there's a couple things you can do. You can request validation from them still without having to get the letter. I recommend doing this in writing. If you can ascertain who they are from the phone call, maybe they tell you, maybe you Google the phone number that called you, and I would definitely recommend doing that to make sure it's not a scam, or at least help you identify if it's a scam or not. You can send a validation letter to any address for that company. Doesn't really matter where. Send it to them. You can also fax or email if you get a fax or email information. Either one of those three should trigger a validation requirement if it's done within the alleged 30 days of initial demand. And even if you don't do it within 30 days, maybe you didn't get the letter, or maybe they didn't send the letter, whatever reason, many times they'll honor the validation demand whenever it was sent. That's kind of on them to do that, and when that 30 days starts is sort of questionable, especially if they didn't send the letter. But the other thing you can do is stop communications for the most part. You can tell them, I'm done, don't contact me anymore. If it's getting too much, you can't deal with phone calls or letters, and you don't want to get an attorney for some reason. Attorney can do the same thing. We can send letters out and tell them to stop communicating with you, but you can do that as well. I'd recommend doing it in writing. If you can't get an address or something like that because they won't send you a letter, I think you're probably okay. Do the best you can, either email, fax, or tell them on the phone if you have to. But tell them to stop contacting you. Again, recommend doing this with a written cease and desist letter. There's a few situations where they don't have to, or they can contact you after you send that letter. So I wouldn't jump right in and file your first pro se federal action against the debt collector because you got an email, you got a letter from them after that you told them to stop contacting you. There's a possibility that is one of the exceptions, and you can get in a little bit of trouble for suing them if it's one of the exceptions. Reach out to an FDCPA attorney and have them look at it and see if it falls within one of those exceptions. One thing I recommend to folks, in any case when dealing with debt collector, is if you can do it, record the phone calls. Not every state lets you do this. Many states are one party, many states two parties. If you're in a one-party state, usually you can record. Check your laws, ask a local attorney. But if you can record the calls, that's great. It's very accurate. Sometimes they record them too. Usually if they're not in their favor, they're going to delete them, obviously, because it's not going to help them. And also know that you may not be dealing with a real person. You could be dealing with AI. There's a couple out there that use AI quite a bit, whether you're talking to them or emailing them, that sort of thing. It's not always a real person. But if you can record those phone calls, record them. If you can't, then just keep really good records of the communications. Note the date, note the time, anything you discussed. These are really valuable if you can get the name of the person. It probably won't be their real name, but maybe it's the name they use in that business, and they can figure out who that is if we send the right discovery request if we need to. Having those notes are great. Many times they'll claim that calls weren't made or things that said weren't said, but they destroyed their recordings. And those notes really set the tone and really kind of set the bar for what probably happened if they destroyed all the evidence that they had indicating what really happened. The other thing I would note is keep track of the time limits for disputing. These are important. Normally there's a 30-day window to officially dispute a debt after receiving that written notice. If you don't receive that notice, though, that's tough. You don't know when it starts. But again, most of them will honor that no matter when you send it. So even if it's outside the 30 days when you get the letter, if it's post-dated or something like that or pre-dated, whatever, just as soon as you can, send out a validation demand. Reach out to, like I said, an FDCPA attorney. I think Google's probably got a little bit. Just basically how to dispute this. I want you to prove it. The statute has some language in there that's pretty solid on that. That said, if you have any questions about this or any other issues related to consumer protection, we're always happy to answer your questions. Cliff Crossing Law, give us a call.